Welcome to Real Estate School. This is the second video in our series, the 5 concepts you need to understand to pass your state's real estate license exam. Today we are discussing co-ownership, specifically the concepts of tenancy in common, joint tenancy, and tenancy by the entirety. So let's get started. There are 2 ways you can own property: by yourself or with somebody else. Ownership in severalty occurs when property is owned by one individual, corporation, or other entity. The term comes from the fact that the sole owner is severed or cut off from other owners. Concurrent estates occur when 2 or more people own the same property. They are called co-tenants or co-owners. Most states commonly recognize various forms of co-ownership. There is one characteristic that exists for all concurrent estates. All co-tenants have the right of possession, the right to use the whole property. Individuals may co-own property as tenants in common or joint tenants. Some states also recognize a special form of ownership for co-owners who are married or in a recognized civil union. During the lifetime of the co-owners, there may be no apparent difference between the various types of ownership. Only when the property is conveyed or when one of the owners dies will the differences become apparent. Today, we'll be discussing 3 forms of co-ownership: tenancy in common, joint tenancy, and tenancy by the entirety. We will review the similarities as well as their differences. Let's get started with tenancy in common. Tenancy in common is the most common form of concurrent ownership. Ownership is assumed to be tenancy in common unless stated otherwise in the deed. Tenancy in common is most adaptable. Tenants in common have different ownership interests, equal or unequal. The deed creating a tenancy in common may or may not state the fractional interest held by each co-owner. If no fractions are stated, the tenants are presumed to hold equal shares. Each of the shares can also be held by a couple, whether married or in a civil union. Because the co-owners own separate interests, they can sell, convey, mortgage, or transfer their individual interest in the tenancy in common without the consent of the other co-owners. A share owned by a married couple can be transferred only with the agreement of both parties. Tenancy in common ownership can be attained at different times. For example, tenant A and B could have obtained their interest in the property years before tenant C obtained ownership. When the type of concurrent estate is not stated, the courts favor a tenancy in common. And finally, a tenant in common can have a will or other legal instrument specifying their interest in the property is to be divided among the surviving owners. But usually a deceased tenant's in common interest belongs to their estate and therefore would pass through their will. Now we have joint tenancy. Joint tenancy is much more restrictive. Most states recognize some form of joint tenancy in property owned by 2 or more people, whether married or unmarried. The distinguishing feature of a joint tenancy is the rights of survivorship, and that wording is included in the deed, or that term, with rights of survivorship. And what that means, upon the death of a joint tenant, the deceased interest transfers directly to the surviving joint tenant or tenants. No formal legal action is required. Essentially, there's one less owner owning the whole. The last survivor in a joint tenancy takes title in severalty and has all the rights of sole ownership, including the right to pass the property to any heirs. So joint tenancy, as the co-owners pass away, joint tenancy reduces down to eventually becoming ownership in severalty. A joint tenancy can be created only by the intentional act of conveying a deed or by giving the property by will or living trust. It cannot be implied or created by operation of law. The instrument must specifically state the party's intention to create a joint tenancy, and the parties must be explicitly identified as joint tenants. Bob Smith and Jamal Jones purchased this property together as joint tenants with rights of survivorship. That wording would be included in the deed. So what have we learned as far as how ownership trades hands? At closing, the seller delivers the signed deed to the buyer who accepts the deed. The buyer now owns the property. So if 4 of us are buying this small apartment complex together as a business venture, and we're going to take ownership as joint tenants, we all need to be at the closing. The closing's Friday at 2 o'clock. We all need to be at the attorney's office to accept this deed together. The seller is going to have one deed produced. We don't each get our own deed. There's going to be one deed delivered to the 4 of us. In order for us to take ownership at the same time, we all need to be at the closing table Friday at 2 o'clock to accept that deed together. So what I'm doing is I'm setting up what we're going to discuss next, these unities that are required for joint tenancy. To create a joint tenancy, 4 elements or unities are needed, which can be remembered by the acronym PITT, like the college, PITT, P-I-T-T, which stands for Possession, Interest, Time, and Title. To have joint tenancy, you have to have PITT. Number 1, unity of possession. All joint tenants hold an undivided right of possession. You own a share, but you're entitled to possess the whole. Unity of interest. All joint tenants hold an equal ownership interest. If there is 4 of us that own a property together, we each have 25%. It has to be equal. If there's 5 of us that own a property together, we each own 20%. But the 2 most important ones, the unity of time and title, and this is kind of what I was setting up earlier. Unity of time. All joint tenants acquire their interest at the same time. We are all there at the closing table Friday at 2 o'clock together. And unity of title. All joint tenants acquire their interest by the same document. One deed was delivered to the 4 of us. So ownership has to occur equally at the same time. If any of the 4 unities is broken, the concurrent ownership is no longer a joint tenancy and becomes a tenancy in common. In some states, identifying the owners as joint owners in the deed automatically includes the rights of survivorship. But use of the wording with rights of survivorship written into the deed makes the meaning explicit. Unless prohibited by state law, joint tenants are free to convey their individual interest in the jointly held property, but doing so destroys the unities of time and title as that interest. For example, Jessica, Melissa, and Christina own a property as joint tenants. Christina decides owning properties just isn't for her. She sells her interest to Madeline. Since Madeline doesn't share the unity of time, she is a tenant in common, while Jessica and Melissa remain joint tenants. You cannot take property as joint tenancy with a corporation, as a corporation cannot die. It can only be dissolved. Termination of co-ownership by partition suit. Partition is a legal way to dissolve the relationship between co-owners of real estate when the parties do not voluntarily agree to its termination. If the court determines that the property cannot be divided physically into separate parcels without destroying its value, the court will order the real estate sold. The proceeds of the sale will then be divided among the co-owners according to their fractional interest. The third type of co-ownership we're discussing today is ownership between married couples, tenancy by the entirety. The property ownership laws of each state identify the forms of property ownership possible within the state. Most states recognize a special form of co-ownership of property that is available only to married couples. Tenancy by the entirety, recognized in half the states, is a special form of co-ownership used in some states that allows a spouse to inherit the other spouse's ownership interest upon death. In this form of ownership, each spouse has an equal, undivided interest in the property. The term entirety refers to the fact that owners are considered one indivisible unit because early common law viewed a married couple as one legal person. Spouses who are tenants by the entirety have the rights of survivorship. There it is again, rights of survivorship. During their lives, they can convey title only by deed signed by both parties. One party cannot convey a half interest, and generally they have no right to partition or divide the property. The property in a tenancy by the entirety is protected from the debt of the other spouse. You can't put a lien on a property, a co-owned property, for an individual's debt. Example, John and Sarah own a house as tenants by the entirety. John loses his job and can't pay his debts. The creditors will not be able to collect the debt by taking the house because such a transfer would require approval by both spouses. A tenancy by the entirety only ends when a marriage ends. Thus, a tenancy by the entirety will end by death. A tenancy by the entirety will end by divorce. A couple buying a property together do not have to take ownership as tenants by the entirety. Maybe it's an elderly couple and one of them would like to pass their interest down to their kids. If the couple takes ownership of the home as tenants in common, then when one of the couple passes away, they'll be able to will their interest to their whoever they decide, pass it on through their estate. Whereas ownership in joint tenancy or ownership by tenancy by the entirety will not pass by the will, it will pass to the co-owners. So let's review a few points. There are 3 concurrent estates: tenant in common, joint tenancy, and tenancy by the entirety. Tenancy in common ownership is the default current estate, and ownership is assumed to be tenancy in common unless the deed states otherwise. In a tenancy in common, there can be a varying percentage of ownership. If a tenant in common dies, title passes not to the other tenants in common, but to that person's estate or heirs. Joint tenancy and tenancy by the entirety hold rights of survivorship again, and that ownership interest is absorbed by the other co-owners. Joint tenancy and tenancy by the entirety both require the 4 unities with tenancy, PIT, but the tenancy by the entirety also requires marriage. If one of the unities of joint tenancy is destroyed, the joint tenancy is terminated and reverts to a tenancy in common. And all concurrent states have the right of possession. One of the most common uses of a tenants in common is a condominium. In a condominium, you own your unit, and you share ownership of the common elements with the other condo owners as a tenant in common. So you own 3% of the swimming pool. Just because you only own 3% doesn't mean you can only swim in your 3%. You get to swim in the whole pool. Unity of possession, and all concurrent estates have the right of possession. So let's go through a few true or false questions to test your knowledge. Question number 1. The term severalty means that there is only one owner of the property. This is true. Ownership in severalty occurs when property is owned by one individual or corporation. Next question. In a tenancy in common, property is owned by 2 or more owners with rights of survivorship. This is false. In a joint tenancy, property is owned by 2 or more owners with rights of survivorship, not a tenancy in common. Next question. The ownership of an undivided fractional interest in a property is a characteristic of a tenancy in common. This is true. In a tenancy in common, each tenant holds an undivided fractional interest in the property. The co-owners have unity of possession of the whole property. It is the ownership interest, not the property, that is divided. In a tenancy by the entirety, neither spouse can convey a half interest to a third party, and neither spouse may take court action to partition or divide the property. Again, this is true. During their lives, under tenancy by the entirety, the spouses can convey title only by deed signed by both parties. The two make one. Our next question. When a joint tenant conveys interest in the jointly held property to a new owner, the new owner becomes a joint tenant. This is false. A joint tenant may freely convey interest in the jointly held property to a new owner. However, doing so will destroy the unities of time and title, and the new owner cannot become a joint tenant, but instead a tenant in common. Our last true and false question. When all of the owner's interest in a joint tenancy have passed to the sole surviving owner, that owner then holds title in entirety. This is false. It's all in the wording. A joint tenancy continues indefinitely until there is only one remaining owner who then holds title in severalty. Let's end today's video with a sampling of questions you may see on your state's licensing exam. Question number 1. The 4 unities of possession, interest, time, and title, PIT, are associated with which of the following? A. Community property. B. Severalty ownership. C. Tenants in common. Or D. Joint tenancy. And the answer is joint tenancy. Question number 2. A parcel of property was purchased by 2 friends. The deed they received from the seller at closing transferred the property without stipulating a form of ownership. The 2 friends took title as which of the following? A. Joint tenants. B. Tenants in common. C. Tenants by the entirety. And D. Community property owners. Well, it's 2 friends. So that rules out C and D. We're down to A and B. The deed they received from the seller at closing transferred the property without stipulating a form of ownership. To have joint tenancy, it requires special wording in the deed with rights of survivorship. So with that wording, it's tenancy in common. Next question. 3 people are joint tenants with rights for survivorship in a tract of land. One owner conveys his interest to a friend. Which statement is true? A. The other 2 owners remain joint tenants. B. The new owner has severalty ownership. C. They all become joint tenants. Or D. They all become tenants in common. And the answer is A. The other 2 owners remain joint tenants. Since the new owner came in at a different time, they cannot come in as a joint tenant, but instead they come in as a tenant in common. However, the other 2 owners remain joint tenants. Our next question. 3 people were concurrent owners of a parcel of real estate. When one of the owners died, the interest became part of the deceased estate. The deceased was A. joint tenant. B. a tenant in common. C. a tenant by the entirety. Or D. a severalty owner. Well, we know it can't be D, severalty owner. That's one owner. And we have 3 owners here. We know it's not tenancy by the entirety because that's for married couples. And since their interest became part of their estate and was passed through their will, it could not be a joint tenancy. It would have to be a tenancy in common is the answer B. Our next question. If property is held by 2 or more owners as joint tenants, the interest of a deceased co-owner will be passed to A. the surviving owners or owners. B. the heirs of the deceased. C. the state, under the state law of escheat. Or D, the trust under which the property was owned? Well, we know joint tenancy has that special feature, rights of survivorship, meaning the deceased interest does not pass according to their will. It is absorbed by the other co-owners. So the answer here would be A, the surviving owner or owners. Our next question. Which of the following is not a form of co-ownership? Not co-ownership. A, tenants in common. B, ownership in severalty. C, tenancy by the entirety. Or D, community property. Well, which is not a form of co-ownership? Only one thing on this list. B, ownership in severalty. Ownership by one individual or corporation. A corporation is kind of like a legal person. When a corporation owns real estate, it's ownership in severalty. Next question. Which of these cannot take title as joint tenants with rights of survivorship? A, husband and wife. B, two female business partners. C, two brothers in a partnership. Or D, a corporation. Well, I think I gave this answer away with the last question here. A corporation owning real estate is ownership in severalty. The law recognizes a corporation as its own entity, like an individual. So anytime a corporation owns real estate, it's always ownership in severalty. Today's last question. All of these unities are required for joint tenancy except A, unity of title. B, unity of ownership. C, unity of time. Or D, unity of possession. Well, if you recall the acronym PIT, possession, interest, time, and title is required. That leaves unity of ownership. B is our answer. Thank you for watching today's video. Please like and subscribe below, and click on that notification bell so we can notify you when we upload our next video.